Good afternoon. Welcome to the College of Labor and Employment Lawyers presentation titled No Nos on Confidentiality and Non-Compete Agreements. We're going to be talking today about the NLRB's McLaren Macomb decision limiting broad non-disclosure and confidentiality agreements, and the Federal Trade Commission's current rulemaking proposal to ban all non-compete agreements. First of all, thank you to Seyfarth Shaw for sponsoring our CLE credits today. Handout materials and a CLE form will be available for downloading during the program in the handout section of your dashboard. If you're on a tablet, this may be found on the menu bar at the top of your screen next to the question mark icon. Click what looks like a piece of paper with the lower left-hand corner turned down. Materials will include the CLE form that must be completed and returned to Seyfarth at CLE@seyfarth.com within 10 business days of today's program. Materials will need to be downloaded during the webinar and saved for later use. I will announce a CLE code during the last 10 minutes of the program, which you will have to note and take down. The handout section is where you will find the CLE form. If you're interested in CLE credit, you can download the form, complete and return it to Seyfarth using the email address provided at the bottom of the form, which for your information is CLE@seyfarth.com. You can also email Susan Wan. If you have questions as we go along, please use the question button to type your question. The questions will be reviewed by Susan and by me as the moderator of this panel. And time permitting, we will try to get to your questions as we go along rather than holding them all to the end of the presentation. Let me first introduce our participants and speakers. Peter Sung Orr, since July of 2021, has been the Deputy General Counsel of the NLRB. He served over 26 years with the board in various capacities, including Acting General Counsel, Regional Director, Field Attorney, you name it, he's been it. He's licensed to practice law in the District of Columbia and Illinois and Hawaii, among others. He's an alumnus of Cerritos Community College, UC Riverside, Pepperdine, and Hawaii Pacific. Yona Rozen, Associate General Counsel of the AFL-CIO in Washington, D.C., began her career with the NLRB, serving 5 years with the regional office in Buffalo and Advice Division in Washington, D.C. She then relocated to Dallas, Texas, where she began representing unions and individuals in labor and employment matters, and in 2014 relocated to Washington, D.C. and became Associate General Counsel for the AFL-CIO. She's a graduate of Pennsylvania State University and obtained her JD at Vanderbilt Law School. Among other positions she holds, she's has served several terms as Union Employee Council member for the ABA Labor and Employment Law section, and has been very active in the Texas Bar Association, is listed in Best Lawyers in America, top 10 women lawyers in Texas. And she is a fellow of the college and currently serves on the College of Labor and Employment Lawyers Board of Governors. Katherine Perrelli is a partner in Seyfarth Shaw's Boston office, where she co-chairs its National Trade Secrets, Computer Fraud, and Non-Compete groups. She's also co-chair of the ABA Committee on Trade Secrets and Interference with Contracts. In Massachusetts, she's been selected regularly among super lawyers and top women lawyers. She helps prepare individual and multi-state employer non-competes, non-solicits, non-disclosures, and other restrictive covenants, and prepares and implements trade secret protections and trade secret audits, among others. John Hamlin is Global Chief Employment Counsel of Marsh McClennan, with over 85,000 employees in 90 countries. He is formerly, prior to joining Marsh, was of counsel with the law firm of Paul Hastings and Janofsky and Walker, served as law clerk to Judge Edenfield in the Southern District of Georgia and Savannah, and is a fellow in the college. Amy Shulman is a partner at Outten Golden in its New York office, a member of its executive and professional practice group, and heads the firm medical employment practice groups. Before joining private practice, she served as a clerk for the Honorable Ida Delgado Colon, then magistrate judge, now U.S. District Judge in the District of Puerto Rico. She is a council member of the American Bar Association section of Labor and Employment Law, and she's on the advisory board of NYU Center for Labor and Employment Law, served as a president of the New York chapter of the Labor and Employment Relations Association, among other activities. And finally, myself, Evan Spelfogel, I'm senior counsel at the New York office of Phillips Nizer. And with that, let me turn to the topic of the FTC's proposed rulemaking. And to sum up very briefly, there are 2 points of this proposed rulemaking. It would be an unfair method of competition for an employer to require any employee at any level, under any circumstances, to enter into a non-compete agreement under Section 5 of the FTC Act. And secondly, the proposal would invalidate retroactively all current existing non-compete agreements, including those in connection with the sale of businesses. Having said that, I turn to our panel to pick up and take it from here.
Sure, Evan, thank you, and thanks for the introductions, and it's a pleasure to be with everyone today. I think one of the things we wanted to talk about just briefly from both the employer and employee or management or employee perspective is how we got here, what led to the proposed rule, at least from our different perspectives. And I'm happy to jump in on that for just a couple of minutes, and then we'll get to some more specific issues on the FTC. So in my personal view, I think this proposed rulemaking is similar to what's gone on in some of the states across the country that have attempted to address significant abuses of non-competes for various types of workers. And there's been outrage over that, rightfully so. And there's been a lot of different avenues that have been taken across the various states across the country. And I can use Massachusetts as an example because I've followed it very closely, having some of my practice here. I practice nationally, but I'm based in Boston, and I've watched the Massachusetts legislature go through this debate over a decade-plus time frame, where it went from complete outrage at some of the low-wage workers that were being subjected to these, whether it's sandwich makers, whether it's coffee makers or hairdressers, and the list goes on, to start with a ban of all non-competes, to various iterations of reform, to what was finally passed a decade after this discussion started, which was a codification really of the common law in Massachusetts with reforms added. Length of restriction, non-exempt employees could not be asked to sign non-competes. Short restrictions, narrowly tailored agreements, notice provisions, right to counsel provisions, that kind of thing. So I guess my personal view, that's I think what has gotten, along with a number of other factors, gotten the FTC and other Congress as well interested in this topic. And we'll get into the nitty gritty of that proposed rule, but I think that's how we got there. But Amy or Yona and John, please feel free to chime in on that topic.
Sure. Thanks, Kate, and from me as well. It's also a pleasure to be here today. I mean, I generally agree with what Kate said in terms of kind of there being this momentum among state legislative efforts. I also think there were some efforts under the Obama administration, and that this is kind of part of, in my view, a more holistic approach of the Biden administration to address competition and wages. I think the statistics show that the rate of new business formation and entry into markets from smaller businesses has been decreasing over the last few decades, and that wages have been stagnant relative to increases in prices. Combining that with the issues that we saw with the pandemic, where some businesses I should say were really struggling to find workers. These are all the lack of competition, from my perspective, the lack of competition or the inhibitions caused by non-competes of competition in the labor market have, I think, been seen by the Biden administration as a serious issue that can be remedied, that are ripe for remedy by non-compete rulemaking, among other areas of legislation and rulemaking. So I think definitely there's been groundswell in the states, but also it's part of a broader attempt to tackle kind of issues of competition and wages at the federal level.
And I just start by saying that it is a pleasure to be here and to be speaking with everyone and discussing, two very very important topics that really go to the heart of the employment relationship, and really to the attempts of employers to try to protect their interests and to really address potential issues that may extend beyond employment. Why we are where we are with the FTC, I think that it really is the abuse that we've seen, certainly for some years. I mean, I remember an article a few years back that was kind of laughable, where a summer camp was trying to impose non-competes on camp counselors. And, if that isn't an example of probably a classic abuse of what should be, what could be a responsible method of protecting, an employer's interests, I can't imagine. I mean, the fact is that responsible employers will use non-competes responsibly. They are, I think, an accepted method if they're used narrowly, sparingly, and only to protect confidential information and other protectable interests, and that they're not being imposed on non-exempt workers, baristas, fast food workers, camp counselors, and I think it's really that abuse that led us where we are. I do think that there has been a lot of variation among the states, and certainly globally, with respect to various jurisdictions. around the globe in terms of their approach to restrictive covenants, non-solicitation agreements, and true non-competes that would limit competition post-employment. But I do think that a complete ban on them is really a direct result, or an attempt to completely ban them in the US by the FTC is really a direct result of the kinds of absurd abuses that we've seen over the years.
So John, as I understand, I think what you're saying is that from an employer's perspective, there's no real problem with an FTC rule that would prohibit limitations and impose non-competes as long as it was limited to exempt employers, exempt employees, for example, high-level employees, employees that would normally have a detailed contract of employment when they're first hired.
Well, I
Executive
can understand.
employees.
I would respond simply by saying that there's a place for non-competes with respect to, we can talk a little bit more about what the contours of such a such an approach might be. I do think that when you have when you're using non-competes to simply as a retention tool, simply to try to prevent your lower level employees from having mobility, that strikes me as an abuse. And I think that a rule that would go to that kind of abuse and try to limit it makes perfect sense. And I can't imagine that an employer would would object to that kind of regulation. I mean, think about what non-competes are intended to address. They're really intended to protect confidential information, proprietary information, trade secrets, and to limit the dissemination of that and to limit unfair competition. I don't think that a camp counselor going to a different camp the following summer and working for a different employer is something that a non-compete is either intended to address or should be permitted to address ultimately. I don't think that it should be enforced, but I do think that there's a legitimate place for non-competes with respect to other types of employees and other circumstances.
If I could just jump in for a minute, I guess pleased to hear from those of you on the management side that at least you're in agreement that with respect to low wage workers, it makes no sense. But I think there are a couple problems I see with what you're suggesting and why I think that what the FTC is proposing is sensible. And that is, first of all, we've dealt with this patchwork in various states where in some states, for example, California probably, there's supposed to be no non-competes. But as the proposed regulation says, demonstrates through studies that were done, that there are workers in California who think that they are bound by non-competes. So I think the patchwork has been problematic because it's not just a question of is somebody truly bound by a non-compete and is it appropriate at what level? And I guess I would also probably we won't necessarily agree where the cutoff should be. Because I think that some of the same issues that low wage workers face would be faced at mid-level and maybe even higher level workers who have unequal bargaining power and unequal abilities to challenge these if they're not appropriate. So that's one thing. I think the fact that there is already confusion under the current patchwork, there is really having a national rule would be beneficial. And then the other thing, I guess a point I wanted to make, I think I sort of made, which is that I do think we probably have a lot of disagreement among those of us on the panel as to where it is that they would be justified. And I guess my other question to those of you on the management side is, when you elucidate what the reasons are why management wants these, can't some of those issues be addressed through confidentiality agreements, trade secret protections, those kinds of things?
Yeah, I'd love to answer that.
Would you have the same view with respect to employees who sign the non-compete not at the commencement of their employment, but at the termination of their employment in exchange for consideration?
Sorry, Evan, were you directing that to me?
Yes.
Yes, the concerns that I have about non-competes are to the extent that they interfere with people's ability to, go find another job. And so I think those same things would come into play, even in a post or termination of employment.
Even where they're paid consideration in exchange for that promise. And the promise is limited, say, to 2 years within a narrow geographic area, perhaps 2 or 3 contiguous states, similar to what New York State now has in its law, permitting 2-year non-competes within New England or the tri-state area in the same industries and businesses.
Yeah, I mean, sorry, Yona, go ahead.
No, go ahead, Amy, because I think you're in a better position to answer that.
Yeah, I mean, and I think, and I know Kate also wanted to jump in. I think, what you're talking about are forfeiture for competition agreements. I mean, so I think there's kind of there's a few conceptual issues that I have with those provisions. The first is a restraint on trade is only supposed to be as narrow as reasonably necessary to protect a legitimate interest. If it is being offered as part of a severance package, whether for consideration as part of a severance package, the gist is that the employer is saying, I'm going to pay you money and therefore I don't think you should compete with me. I don't see that as, I understand it's an interest of the employer, but I don't see that as an interest that warrants restraint on competition. So I think the concept of that takes it out of the reasonableness, makes it an unreasonable restraint on trade because it's not protecting a legitimate interest. The notion of the forfeiture for competition is that in some states courts will say, we don't have to review this clause for reasonableness because the employee is not going to be sued in court over it to prevent them from competing. What it means is that the employee will forfeit some form of compensation that's tied to competition. The challenge is that a lot of times the compensation tied to competition is extremely large, such that it might as well be, there's really no fundamental difference between whether the employee were to be sued in court and subject to a potential injunction from working for another employer versus forfeiting competition versus forfeiting the compensation. How I think many of us on the employee side view those clauses is that it's simply a non-compete with a pre-designated remedy. Or a liquidated remedy. A lot of times those clauses also say in the agreements that I've seen that the employer can still seek injunctive relief. But even putting those situations aside, changing the remedy doesn't change or pre-designating the remedy doesn't change the restraint on trade. Somebody shouldn't be forced to sit out of their career or limited in their ability to change jobs because they want to retain compensation for work they've already performed. And so, you know, those are, I mean, this is a topic we could spend, you know, hours on, but those are kind of some of the high points of at least my views on these clauses. I know Kate wanted to respond differently.
I'll let John respond to those provisions, but I wanted to, and I'm happy to chime in too, but I wanted to first talk about Yona's comment on why aren't confidentiality provisions, non-disclosure agreements, non-solicits, I think you mentioned too, Yona, why aren't they sufficient? And the problem with those as being the sole protective measure for an employer or business trying to protect its confidential information and trade secrets is that, you know, on the flip side, non-competes are preventative. They're more preventative than those provisions. They prevent competition and disclosure before it happens, or at least they try to, if they're enforced. With confidentiality agreement and trade secret laws and misappropriation claims that you have to file to protect those rights, the harm has already occurred. It's typically the person has taken the information, is using it, you find out about it, you sue, and the cat is out of the bag, so to speak. The key to the kingdom has been unlocked, and the damage is done. It's irreparable. And if you back up to sort of the market economic foundation for a lot of what I view anyway, the FTC bases its proposed rulemaking on, is a lot of economic studies, market analyses on how this is going to impact and increase wages and protect employees. I think many of those studies have been questioned. They're inconclusive. There are causation issues with them. And the harm that is going to occur by instead asking employers just to focus on non-disclosure and confidentiality agreements, the harm will have happened. And these I litigate a lot of these cases, both non-compete cases when they're being enforced or trying to enforce them. I litigate trade secret cases as well on both sides. Trade secret cases are very, very difficult to prove. It's a very high bar. They're very expensive, much more expensive than a non-compete case, which typically ends at the injunction phase, whether if the employer wins or loses, or if it's trying to enforce the non-compete. These trade secret cases go on for a very long time. They typically go to juries, and they are extremely expensive for businesses to protect. And that's it. And as I said, the damage has been done, the secret's disclosed, and then you have to prove your damages, your monetary damages. So I think that the sort of the initial response to banning non-competes is that you are protected through these laws. It's not the same type of protection, and I think they're going to cause, if this passes, and that's what employers have to rely on, it's going to increase costs. And I think there's a lot of other unintended consequences that are going to impact employees. And I won't take up all this time on that. We can come back to that. That have not really been thought through very well, in my view, by the FTC, and a number of industry groups have pointed that out. But we can come back to those. But I think that's the answer, Yona, to your question. I just wanted to make sure we had out there. I'll let John talk about the agreements and those.
Well, I feel I wanted to add to what you were saying, Kate, because I think that if the use of non-competes is limited to those who have, truly significant confidential proprietary trade secret information, I think that there is an important use for them in certain circumstances. For example, if somebody is sitting on an executive committee and has access to all of the business plans, all of the sensitive information about a business, truly sensitive information about a business, I think that if they were to leave and be able to immediately start working for a competitor, it would be very hard to prevent inevitable disclosure or inevitable use or misuse of that information, because that individual would be obviously would be involved in the operations and the leadership of the new organization, and would have a very difficult time not at least making decisions based on the confidential information that they have. And I think this whole doctrine of inevitable disclosure in restrictive covenants is actually useful with respect to those particular highly placed business leaders who have that kind of information that's sensitive and proprietary. And really, the after the fact, common law remedy, if there's been an abuse, first of all, proving it can be very difficult in circumstances like that. And ultimately, I think it's not going to be sufficient to protect the legitimate interests. But if non-competes are used narrowly with senior individuals, with senior leaders, with those who truly have that kind of information and who are highly compensated, I think that the impact on trade is going to be very, very limited, and I think that it will be a benefit to business and a benefit to fair trade in order for those agreements to be permitted.
John, it seems to me that these kind of agreements are entered into primarily at two different stages of employment. When an employer is recruiting and hiring a high-level executive suite level employee and agreeing on the compensation to be paid to that employee, and insists on a non-compete agreement if and when that employee leaves the employ of the company. That's one situation. The second situation is where an employee is leaving the company's employ, either voluntarily or involuntarily, and the company is considering severance pay. At that point, a partial consideration for the severance pay is a limited non-compete agreement within a narrow geographic area, within a narrow industry area. And in those two situations, it seems that there may be, from what I'm hearing from you, valid reasons for a legitimate non-compete, limited in scope, limited in duration, limited in geography, limited to the industry. And if the FTC is going to invalidate that, what happens to the consideration in the first situation where the company has agreed to pay the high-level executive suite person a certain compensation and benefit level in return for, among other things, the non-compete, limited non-compete if and when that employee leaves the employment? Does the employee have to pay that all back? Is the FTC proposing some sort of make whole?
No.
How
No.
are the proposals handling that?
I mean, I think that it would depend on the agreement itself. If the agreement were to provide for, if this is held to be invalid and you are released from it, then you will repay. I mean, I haven't seen an agreement quite like that, but I suppose that's possible. Whether or not it would be enforced or how that would unfold or be resolved, I don't know. But the retroactivity of the FTC's rule is problematic in the sense that I would be less concerned about a non-compete that was considered at termination, but that hasn't been entered into yet. But for those agreements that are already in force, I think that could be problematic. This is particularly true with respect to the sale of a business. If you are, the FTC's rule would permit non-competes in the context of a sale of a business, which, by the way, even California would permit, but only with respect to those individuals who who have been paid 25% of the value of the business, who are 25% owners of the business. And so you could impose a non-compete on somebody who's a 25% owner, but not somebody who owned less of a business. That's true even if the business is $100 million business, and if they had 10% or a $10 million value, they then under the FTC rule, you could not impose a non-compete on them. The problem with the retroactive application of the rule in the context of a sale of a business is that you have businesses that were valued and where shareholders were paid for those businesses in the context of the enforceability of a non-compete that protects the asset that has been purchased. And if you're now going to say, you know, those are now invalid, then you're going to have a lot of you know, acquisitions that have taken place in the last few years that may be viewed very, very differently by the acquirers. And I mean, this really amounts in some sense to a taking of that value potentially, because these people will now be free to compete. I mean, under the FTC rule, if someone were to buy Amazon, Jeff Bezos could not be covered under a non-compete. That seems like it would be like it's counterintuitive. We're going to need to have a different threshold, I think, other than 25%, whether it's a hair salon or a $100 million company.
The good news is that the FTC has indicated, you know, I have lots of issues with the proposed rule, but the good news was that they did indicate some openness to alternatives on this. So hopefully, I mean, even California doesn't have that 25%. They don't have that benchmark, thankfully. You know, and I think just on that point, just to Evan, back to yours, the FTC, and I think their estimates are, you know, there's no way really to test their estimates, but they estimated there are 30 million non-competes that exist in the country now. So that's 30 million previously agreed to financial arrangements that are going to be undone with one fell swoop if this passes. And, you know, all the way from the types of transactions that John was describing to, you know, the impact on small businesses and startups. I mean, many of those are founder seeded companies that, you know, family and friends invest in and invest money in hiring employees and, you know, tying some of those employees to non-competes because of the confidential information they have to. And you're going to be in, you know, the proposal is to invalidate those investments, and it's going to be a great loss of money just for the business owners, never mind the impact it's going to have on employees as these things move forward, if it passes.
So, Evan, can I respond to some of that? Or Yona?
Yona, I think you're on mute, yeah.
Go ahead, Amy. I'm sorry.
Yeah, I mean, I think obviously there's a lot, and again, you know, we could spend hours talking about these issues. I mean, I think the issue with respect to retroactivity is important because I'm hearing some feedback. I don't know if anybody else is hearing it. So the issue with non-competes and why retroactivity is so important is that there's really no incentive, and I'm not saying employers on this panel or even in our audience, but there's really no incentive for employers to draft non-competes that are not only, you know, reasonably limited in scope, but that are reasonably and only very selectively imposed. Typically, what we see is that in our practices is that non-competes are fairly broadly applied across organizations. They've kind of become this default, quote unquote, standard boilerplate clause. And if you try to negotiate them, most of the time, more often than not, the initial response from employers is that this is our standard clause and we can't change it for anybody. And in my view, that kind of dilutes the notion that these are important to protect some information or secret that this particular employee has by virtue of their job. Typically, these are kind of reflexively issued throughout organizations, vertically, horizontally, without kind of any correlation to what the employee is actually doing, including at senior levels. So, for instance, in the healthcare industry, when you're talking about income levels or people who are in senior positions, a physician may be in a very senior position and may exceed a certain income level. That doesn't mean they have any trade secrets or proprietary information that would justify, in my view, preventing them from working for another practice within the same community of patients. So I think in my experience, the notion that these are kind of tied to the information given to the employee is not really borne out. With respect to kind of what employers have argued or the ineffectiveness of confidentiality and trade secret laws, it's essentially kind of putting the cart before the horse. It's essentially saying, we anticipate you're going to violate this rule, and therefore we're going to prevent you from or inhibit your ability to leave your job in anticipation of that. And any other type of claim in employment, is you have to have the injury first before you can impose the remedy. This is essentially imposing the remedy before there's been an actual breach of confidentiality and trade or trade secret. I mean, I think it's essentially saying to employees, even though your new employer doesn't want your information, and even though you've already agreed not to disclose this information, we're going to take this extra step of prohibiting you from going somewhere else, no matter whether we want to keep you or not, or how we're treating you. It's a remedy that presupposes a violation and that's not targeted to the actual damage that's done to an employer. As with every other type of claim, you need to prove your damages. Employees, if they are defamed by an employer, they need to prove, unless it's special damages, they need to prove their damages. And so this kind of alleviates an employer's burden of having to, and shifts the risk to employees of having to prove damages from any alleged violation, as they would with any other type of claim. And with respect to retroactivity, just the issuance of a non-compete, regardless of whether or not it's enforceable, has a very kind of widely acknowledged chilling effect on employees. And so without retroactivity, you still have broad swaths of workers who are going to be prevented from working in their field, regardless of whether the non-compete to which they're subjected is enforceable or not. Workers typically can't afford to take the reputational or economic risks of challenging the non-competes. Without retroactivity, the harms on the labor market of the rule are just simply perpetuated.
Couple
No,
of
Yona, chime in.
Amy, a couple of questions from the audience, and I'll try to paraphrase these. The first question is, why isn't common law trade secret law sufficient to meet any legitimate employer interest? People who walk off with trade secret, proprietary, confidential information are committing a tort, which is remediable in court. The second question, which is also for the employer side, isn't it problematic to talk about limitations on exempt? In other words, limit the, agree to limit the, or offer to limit the restriction to exempt employees when the classification of exempt is abused by many employers?
Well, I would say that, you know, limiting, if the rule were simply to limit the use of non-competes to exempt employees, it wouldn't necessarily be addressing all potential likely abuses. I'd agree with that. But I do think that that at the very least that the rule could prohibit their use with respect to non-exempt employees, or that there could be some income threshold. I mean, I'll give you an example of our own company. We have a number of we utilize non-solicitation agreements. We utilize you know, certain confidentiality agreements with respect to proprietary and trade secret information to try to protect all of that. We use non-competes very sparingly. We have 85,000 employees, probably half of those in the US. And among our US employees, I want to say there are under a dozen who are subject to non-competes. They are literally, you know, the C-suite folks who have access to highly confidential information. And we have a 2-year non-compete for our CEO and a 1-year non-compete for other executive committee members. Apart from that, we use non-competes with respect to those who were former owners of businesses we've acquired. We're using non-competes very sparingly. And I could see where simply exempt employees could be, you know, having exempt employees permitted. I think that may not address the abuses, but I also think that the use of non-competes needs to be reasonable. If, you know, and they've always, you know, certainly under the law in New York and many other jurisdictions, they've needed to be reasonable. There has to be a legitimate protectable interest that the agreement is intended to protect. And I think that that's something that we may lose sight of. Imposing them on lower level workers or those who have no confidential information, who we don't have an interest in limiting their post-employment activity. I think that would be understandable that people would object to limitations that make no sense. I do think that one area that would be worth discussing is this whole notion of this de facto non-compete. I mean, the FTC has basically said not only non-competes, but anything that has any other types of agreements that have that really function as non-competes, even if they don't literally prevent people from working. And that would include non-solicitation agreements, potentially other agreements, I suppose, as well. But non-solicitation agreements, I mean, there are, you know, the individuals who are working with respect to customers and clients have confidential information by definition on those with respect to those customers and clients that will give them an unfair advantage if they leave and go to another employer. And so to limit their ability to solicit or service those particular clients seems to be to make a lot of sense, and doesn't prevent them from going and working and competing fairly with another employer. Those sorts of agreements, notice periods, non-solicitation agreements, that I think the FTC has indicated could be prohibited. I question whether or not that's going to, in many instances, do much more than simply increase litigation over the enforceability of those over those agreements on a different basis. In other words, the FTC says it might be a de facto non-compete, so therefore we're gonna now litigate that. It seems unnecessary.
Kevin, can I just follow up on one point there?
People, we're going to be turning to the NLRB's McLaren decision in just a moment, but I have a final question to throw out to the panel on this. Does anyone have information about the status of the proposed rule? Has the time period for submitting comments now
Closed?
expired?
I think there were like 28,000 comments. There were a lot of comments. So at some point, the FTC has to review all those comments, and then they will issue a final rule, which may, be similar to what they've proposed, or may be different from what they've proposed. And then, of course, I'm sure it will be challenged. So I think we're a long way from having something that's actually in place.
There was a Bloomberg report just this week, I think it was, sort of a strange reference in it to a person familiar with the matter. That was the source, which is kind of a loose reference in my view. But they indicated that the FTC expects to vote in 2024, April of 24, which is about 16 months of consideration and rulemaking, according to the Bloomberg. That's not unusual. So it's next year, and they will vote on the rule at that point. And as I understand it, the commission still hasn't filled the resignation spot of Commissioner Wilson. So it's Commissioner Khan and two other.
Thank you, people. I understand that Associate General Counsel Peter Song-Orr has joined us. And with that, I'd like to turn our focus on the board's February of this year issuance of its decision in McLaren Macomb 372 NLRB number 58, in which the NLRB held that employers violate the act when they offer severance agreements that require employees to waive rights under the act. I'm not quite clear on what rights under the act are covered by that. General Counsel Orr can perhaps clarify that. But I think the focus in McLaren was on what was called overly broad non-disparagement and confidentiality provisions, which the board views as tending to interfere with Section 7 protected rights. And of course, in discussing Section 7 rights, I have to count on the panelists to remember that there's a second part to Section 7, and that's the right to refrain from any and all protected concerted activities. So with that, let me turn this over to Associate General Counsel Peter Song-Orr.
Evan, thank you very much. My initial apologies for joining the panel a little bit late. With technology as it is, sometimes it doesn't work perfectly. I did have the opportunity to listen in to the first part of the panel discussion, and with regards to the FTC rulemaking, and it's certainly not at the NLRB's wheelhouse. We have interest in the proposed rules, and what struck me with regards to the proposed rules is that from the discussion of the members, the fellows of the college, if that was essentially what was in dispute, from what management representation, union and employee representation, there really isn't that significant amount of dispute in that we're talking about a very small percentage of employees that everyone agrees these non-competes should apply to, and what those non-competes should state. And so I think if that was the world that we were looking at, there wouldn't be this concern that's been, as you folks have seen in headlines about, specifically with the McLaren case, about how non-disclosure provisions are now outlawed, which is not the case under McLaren. It is simply that the separation agreements, as long as they are narrowly tailored, because of the inequities, imbalance between employees and employers, because of the natural imbalance that the National Labor Relations Act was meant to address, having these separation agreements that can be interpreted by an objective standard by employees to chill the employees right under the act, which is to converse, to discuss about terms and conditions of employment, some very favorable to the employers, some perhaps not favorable to the employers. With employees in the future, employees from the past, about terms and conditions of employment, as long as it doesn't interfere and chill those activities, separation agreements are not de facto unlawful. And as long as it's narrowly tailored. I mean, again, within our discussion among the members of among the fellows in the college, there may not be a great dispute, and as it wasn't perhaps in the FTC discussion, but there was a reason why the McLaren decision issued. Just short facts about that case dealt with 11 employees of the employers whose jobs essentially was to serve as greeters. That was it. And when they were laid off, the layoff was not in dispute, but when they were laid off, the employers had them sign a severance agreement, which stated that disparaging comments, confidential information, discussing with employees cannot be allowed pursuant to the severance agreement. And who defines what is confidential information? Certainly trade secrets, copyright information, those realms of material, I don't think people are going to dispute. But if it is an open-ended kind of definition, and again, considering the imbalance between employees and employers, is the employee reasonably going to believe that what was discussed at the workplace, both favorably and perhaps unfavorably, can be discussed outside after their work period ends? And I think that is the discussion that when the board overturned Baylor, made clear that it does have a tendency to chill employee Section 7 rights to engage in protected concerted activity or refrain, as Evan points out. But it can't be where it is imposed upon them And as again, just closing up by saying, as Kate mentioned in the FTC discussion with regards to non-competes as a preventative measure, and the reasons why it is worthwhile as a preventative measure to have non-competes, I think it's the same for Section 7 rights too. In one hand, one could argue, and the General Counsel certainly is looking at non-competes, non-solicitation agreements in the same vein as these severance agreements, but it is a preventative measure, not just for the employers, but it's a preventative measure for the employees too. And that preventative measure results in there being a chilling effect, refraining employees' ability to exercise their rights under the National Labor Relations Act. So there's two sides to that preventative measure. And who is in the best place to make sure that if there is a legitimate business interest, that the legitimate business interest is in fact addressed narrowly versus it being so wide to interpretation that an employee is unable to objectively discern, is this something after their employment period ends that they can disclose or discuss versus them having a lawsuit brought against them for potentially talking about what happened at the workplace. And again, in our discussion, we're not talking, in our discussion, none of this would apply because I don't think anyone is saying here the hourly workers, the visitors, the employees who greet patients as it was in McLaren. No, I don't think anyone's saying that these provisions should apply to them. But we know that they do. These types of agreements do apply to hourly workers, employees who do not have proprietary information that they even could disclose. So that's kind of a broad perspective from the General Counsel's point of view as to the severance agreement and how it kind of ties in with the non-compete. And we could talk about specific parts of the McLaren decision and the applicability of it as we go forward.
Peter, generally in severance agreements that employers enter into with employees who are departing, either voluntarily or involuntarily, there are provisions that say the employer is going to pay a certain amount of severance pay or some other consideration to the employee. And in return for this, the employee agrees not to disclose the terms and conditions of the settlement agreement. That is, that money is being paid, how much money is being paid. Is that prohibited now by McLaren?
The actual terms of the settlement, the monetary terms of the settlement, is not impacted by McLaren. In fact, I would say if you look at the National Labor Relations Board's settlement of unfair labor practice cases, there are often non-board settlements that parties enter, and the regional director approves the withdrawal of the case where confidentiality, narrowly tailored confidentiality with regards to the terms of the settlement, the amount of money, excluding spouse and legal counsel, are approved. So it doesn't address any of those. It is about terms and conditions of employment and whether employees can discuss those after leaving their employment.
So, Evan, I think that in answer to your question and following up what Peter is saying, I think what's important here is, and I've certainly seen this in settlement agreements where there's very broad language that's not just protecting this is the amount we paid to settle this case, but it's saying you cannot discuss the facts that led up to, where there were allegations. You can't discuss the terms. So, I mean, those are the things that the board would be concerned about. that I can't talk about what the conditions were when I worked at this employer. Not that I can't talk about how much I was paid in resolution of my case. And I think Peter makes reference, and specifically the GC after McLaren, Jennifer Abruzzo, the general counsel, has issued 23-05, which is included in the materials. But that makes specific reference to memorandum OM 07-27, which and says that that's still in effect, and that that's where it lays out the provisions of when a board office is concerned about the public interest and is looking at a non-board settlement, whether they will approve withdrawal of the underlying charges. And that's what Peter's referring to. And it specifically says you can make confidential the amount of the settlement. But the problem is where you have these broad clauses that go way beyond the amount of the settlement.
So would that hold true with respect to severance payments associated with the severance agreement, that the amount could be maintained as confidential? Is that the board's position? Because I don't think that that was clear. It may have been clear in other contexts, but I don't know that it was clear in the McLaren decision.
Right. The McLaren decision specifically talks about the confidentiality related to work, the terms and condition of at the workplace, and non-disparaging comments. Specific to the amount in the severance, that was really not at issue. I think it becomes that issue. It becomes that issue because if the severance agreement is null and void, then the amount and whether the disclosure of the amount is still then confidential it comes into play. But that was not the issue at hand of why the severance agreement was found to be unlawful.
Here, can I ask a question? We talked a little bit about this when we were preparing, I think, for this. The reference to the in the memo that the GC issued, and you mentioned sort of a look at, also looking at non-competes and other restrictive covenants to the extent they might run afoul of Section 7. And you mentioned, I made the use of the phrase preventative measure, and you said something along the lines of who's in the best place to determine whether the legitimate business interest is protected by the particular provision. So I wanted to hear a little bit more about that, because in the outside of the NLRB context and the non-compete context in state courts, the court is determining that. The employer's counsel has to make the case that there's legitimate business interests and show a likelihood of success, and then the court decides if you've met that burden, and then of course it goes on from there. But I'm interested just to hear, and I'm sure others are too in the audience, how the non-compete provisions would fall within the concern of the NLRB in the McLaren context.
I don't think, broadly speaking, it is significantly different and I don't want, I want to be careful that I don't get ahead of the general counsel, because there is consideration right now as to as is referenced in the GC memo about other provisions. But I think broadly speaking, how employee Section 7 rights may be interfered or chilled if certain provisions are placed upon the employees. For example, in the non-compete arena, having outside of the exceptions and the CEO employees that we had all talked about earlier, but if the non-compete is so broad that it prevents employees from legitimately prevents employees from working at another location in a similar industry, the consideration that in fact chills an employee's ability to exercise their Section 7 rights. One of the important aspects of exercising Section 7 right is withholding a person's work, quitting their job, compelling, discussing with employees about that, or refraining about that. But if the non-compete is so broad that, in fact, that aspect is actually undercut, meaning that the employees do not have an option to go to another workplace, then, in fact, that has the impact of chilling an employee's ability to exercise their Section 7 rights, because everybody knows you are not, the employee is, in reality, has no option. So by having no option, that in fact takes away their Section 7 rights. And I think just kind of broadly looking at these provisions, and does it have an impact from the employee's, reasonable employee's perspective, to be able to exercise their Section 7 rights with other employees, or is it in fact by undercut their rights? And I think, so from the no solicitation to the non-compete, I think that is kind of the arena, the lens that the General Counsel Bruzzo is looking at. I don't know if that's helpful.
No, it's helpful. Thank you.
And Kate, one other aspect I would say is that the board has issued a decision several years back, I think to 2017 maybe, in Mintech, which says that non-competes are a mandatory subject of bargaining, so that an employer can't proffer a non-compete. This would be obviously in a situation where there's a union at the work site. But why that's important is, even though it's something that controls after you leave employment, that's considered part of your wages, hours, and working conditions, and that would be why it's mandatory. So.
But I think in any context, I would hope that any non-compete provision that prevents any other employment anywhere wouldn't be held up in any venue. So.
Yeah, and I know Mintech well, because that came out of Region 13 when I was the regional director. But it is interesting. It would be terrific if these discussions about the limiting effects and the application was, again, happening amongst us. I don't think there would be much in dispute. And as often happens, the headline grabbers are not reality. But as we saw from the McLaren decision, there are those provisions that are overly broad and applying widely to even the employees that do not have those informations.
We were talking about this during our what about, a lot of times agreements will have, in our experience, very broad confidentiality and non-disparagement provisions, and then there'll be a separate clause saying to an employee, nothing prohibits you from exercising the right to go to the NLRB, or some sort of savings clause. What's the board's position as to whether that vitiates the problem of the overly, in our view, overly broad confidentiality non-disparagement provision, or whether it kind of, you still need a narrowly tailored provision, and you can have a savings clause as a check and balance, is I-dotting, but it doesn't actually save an intentionally unlawful clause or overbroad clause.
I mean, I think those are real life situations, and I know the General Counsel appreciates how that actually works. And while this is not, the severance agreement world that we're talking about is not employee handbook rules that are currently governed by the Boeing decision. But I'm sorry. I say that because there is a discussion about savings clauses and potentially unlawful provisions in employee handbook, that discussion has been ongoing for a while. But it's always been the board's position, and certainly the general counsel's, that encouragement of providing clear guidance to employees so they understand what their rights are, and that, a savings clause that clearly demonstrates and discusses what the employee's rights are with regards to what they can disclose or state. I think that's always a favorite. That said, there's still concerns that the savings clause is not necessarily a get out of jail card either. That, again, looking at the imbalance and the public interest that the agency is looking at, not just for necessarily that one employee who may know what their rights are and be confident about their rights. We're looking at the public interest in these severance agreements. If there is a provision that is inconsistent and unlawful, juxtaposed to a savings clause that says, everything that's lawful is lawful, that inconsistency is going to be difficult to address, as it still not having chilling effects on the employees, objectively having chilling effects if they are so inconsistent. I don't think that's difficult to address, but again, sometimes, how we all know how agreements and employee handbooks are sometimes put together piecemeal, and it's not gone through at one time to make sure the inconsistencies aren't there. But if there are inconsistencies, especially as a drafter of the document, it will most likely go against the interpretation of the drafter, right? I think also, as a pragmatic matter, and on the savings clause, proximity matters. Proximity as to what the confidentiality, non-disparagement language in the severance agreement states, the narrowly tailored. If it's right after one another, so that an employee reading the information knows that this applies to that, versus page 30 of the severance agreement, when the confidentiality provision is on page 1, that makes a difference. So I think it's encouraged. I think it's for the public's interest, and I think for everyone's interest to have saving clauses, but it's like everything else, narrowly tailored, and has to be reflective of what a reasonable employee would understand that to include. And again, the spell is I will say also on the General Counsel 2305, that is a product worked on by the General Counsel after a number of conversations, from bar meetings, the presentations throughout the country, where employees and employers, after the McLaren decision issued, had raised questions about the applicability of that decision, and this was an attempt to address many of those particular issues. Not all, but many of the big issues.
A number of years ago, when the NLRB was focusing on the terms and conditions of employment handbooks, the General Counsel published guidelines, suggested language that would be illegal or would be legal, and came very close to publishing a suggested broad-based handbook. Does the General Counsel envision perhaps issuing any guidelines with respect to severance agreements?
There is no consideration at the moment, Evan, of putting together a similar type of guidance. I believe it's under General Counsel Leif Solomon, where certain provisions in the handbook, and obviously we're talking about many, many more provisions in the handbook versus just a severance agreement, but whether those would be interpreted by the General Counsel to be unlawful based on the Lutheran heritage status, Lutheran heritage legal standard back then. I don't believe there was ever a period of time, and even certainly in the field, when serving as regional director, where the agency provided language that would be lawful, but simply whether the interpretation of that language would be unlawful under the Lutheran heritage standard. And so because the extent board law is different currently, there wouldn't be that kind of guidance going out anyway. But and in particular because of the severance agreements have more narrowly focused concerns, there hasn't been any discussion about doing that right now.
A question from the audience along similar lines. In McLaren, the person who raises the question comments, it was a group layoff, a group contract, what you might call concerted activity. Did that fact play a part in the NLRB's decision in the McLaren case? So that the decision might not be the same if it were a single employee termination?
Well, I don't know. I don't know what the board was thinking about and what it influenced them. I do know from the General Counsel's perspective, this is an 8A1 violation, which is an objective standard with regards to the provisions having a chilling effect on a reasonable employee. So I suspect as people having understanding motive, potential motive, may impact how people look at cases, but the legal standard, it really should not have, right? Because objectively, did it have a chilling effect, and that's a standard.
Peter, it's interesting because when I read the decision, I was really wondering whether not only the fact that it was a group layoff, but also the fact that the union had failed to, or the employer had failed to involve the union with respect to the furlough, the ultimate termination, the provision of the severance agreement itself. There were already violations that the board, the judge found and the board upheld with respect to the union's approach before the board even got to the language. And if you look at the language in not only the confidentiality provision, but also the non-disparagement provision, they're about as broad as you can imagine. There's no even attempt at a savings clause or anything. And I sort of felt like the employer was almost daring, the board, or at least, approaching this in a manner where the board would be hard pressed not to find a violation. But I also took it from what the board said is that all of the other violations didn't really matter. It was really the language itself, and it would be problematic whether it was applicable to a single employee in a non-unionized setting, to the extent that that language was chilling. And they weren't just saying that language was unlawful, but really any language that would even remotely chill Section 7 activity, Section 7 rights, would be unlawful.
I think you're absolutely right, John. While, as we all know, as practitioners, certain facts have a way of compelling certain decisions, and certainly the facts in this case with other violations, as a layperson, could look that way. But as you point out in the decision, and I think clearly based on the section of the Act and the legal standard, it was compelling for that conclusion to be reached. But even without the other violations, the section of the Act, as you state, in this really broad language about confidentiality, who's to determine what is confidential? It could be anything, right? To what is non-disparagement. It, to me, and certainly the General Counsel and I agree that as an objective measure, that those would have a chilling effect. And the other violations is not inconsistent with the employer's act in that case.
Yeah, I think if you go back and read the decision, there's no question that the fact that there was a group layoff, this language, if it was given to one person separate and apart from the group layoff, I think was still a problematic for the reasons that Peter laid out.
Mm-hmm.
Yeah.
And Evan, if I may, and I know because we are rapidly approaching our end, one of the, if I may, one of the questions or issues that have come up since the McLaren decision that General Counsel Abruzzo addressed in the GC memo, and I think it's worth noting, is the retroactivity aspect. I know you folks talked a little bit about that in the FTC rules, and from the enforcement aspect of the severance agreement and the proffer of such unlawful. And I think there's a little bit of clarity that I hope I could bring to some of that if I could address that.
Well, don't board decisions always have retroactive effect?
Unless the board states otherwise. Yeah, absolutely correct. And so how does that apply in these severance agreements that we know are often, now we're already 3 months into the board decision having issued. So as we all know about the 10B period, 6 months, if a unlawful severance agreement had been entered into 3 months ago, we were rapidly approaching the 10B period on the entering into the severance agreement. However, what would be still a violation, although the severance agreement was beyond the 6 months, is the enforcement, as you were saying, Evan, about the unlawful provision. And then they will bring it back into the 10B period. The other aspect, and so I just want that was clear. And the other aspect of that is what is truly within the 10B analysis is just a proffer by the employer of such unlawful provisions, and that in and of itself being unlawful. Certainly, if that proffer was made 6 months ago, then it would be 10B, but National Relations Act.
Just to
Yeah, we're
getting some feedback from some of the sounds. Just to follow up on that, what if in the settlement negotiations and the agreement with the employee, the language says that nothing in the settlement agreement shall limit an employee from participating in any federal, state, or local government agency proceedings, from filing charges with the National Labor Relations Board, or participating in NLRB proceedings. However, the employee agrees, in view of the fact that he's getting severance pay, that he or she will not collect any money in such agency proceedings.
Well, I mean, I think that I have we haven't seen. I'm not familiar with a situation where there's an agreement like that, and whether that proffering that type of severance agreement in and of itself is unlawful. With that kind of savings clause, I don't know for certain that that would be unlawful, because under the National Labor Relations Act, employees have a right to obtain the remedies that are provided under tenancy of the act, and it is a, and again, it's not just necessarily for that employee, but for the enforcement of the act for the public. So excluding an employee's ability to obtain the remedy, is that in and of itself unlawful? That would have, I mean, I would have to give that some further thoughts. But I think that one of the interesting aspects of that question, though, is when we often see settlement agreements for an employee separate and apart from the National Labor Relations Act, and the employee receives compensation that would be equal or greater than the back pay an employee would receive under a ULP, and that payment being sufficient to address the back pay amount. And so I could potentially see that being addressed through your scenario. I just don't know beyond that whether there is, because is there still a chilling effect because the employee is still unable to obtain the remedy that they normally would have otherwise, which would then have them not exercise their Section 7 rights. That is hopefully something we won't have to encounter, but if we do, then we'll have to address it when it comes in.
By the way, let me announce for all the participants the CLE code for today's program. Those of you who are seeking CLE credit should jot this down. The code for today's program is S as in Sam, S as in Sam, 7425. That's two S's, 7425. And we still have another few minutes. We can continue with our discussion.
Can I address one of the questions, Evan? I think it'd be good for us to just make sure we do mention this. One of the questions was whether the FTC's authority to engage in this rulemaking will be challenged on the major questions doctrine, on the basis of the major
Yes.
questions doctrine. I think it's safe to say that it will likely be, depending on what the ultimate rule is that's passed. That has been one of the big criticisms of the FTC, whether they have the ability to do what they're doing. And major questions doctrine, which recognizes that when delegating rulemaking authority to agencies on major questions, Congress does not usually hide elephants in a mouse holes, is the phrase that everybody keeps citing to, and that there should have been or would have been a very specific delegation of this authority after hundreds of years of state law on the question. And then even if it had been delegated, that might be outside the Article 1. So we'll see. Time will tell. But I would imagine that would be a challenge.
Do we have some final comments from our panelists on either of the two topics of discussion? We couldn't have answered all of your concerns at this point.
Yeah, I mean,
I mean,
go ahead.
go ahead, Amy.
Amy?
Go ahead. No, Peter, go ahead.
I'll make it quick because I'll be just repeating what I've said a number of times already. That while the McLaren decision or a line Lamastre that issued with regards to losing employees' protection under Section 7 rights, those types of cases have great headlines and potential, you know, the sky is falling kind of imagery, they're often easily resolvable and avoidable. Not necessarily because people want to evade the law, but I think in practice, both management, labor, employee side understand the practicalities of the work at the workplace and how it impacts, whether it be National Labor Relations Act or other workplace protection laws, that in the reality that the practice should be already addressed because it makes for a better workplace. Forget about the law. And I think that's ultimately what happens. And luckily, we don't get to see many of those cases that come before us because in practice, they are moot as issues at the workplace.
Yeah, I mean, along those same lines, I would add, you know, with respect to the FTC rule, I mean, I think the major questions issue that Kate mentioned, I think obviously will be debated among proponents of the rule and opponents. You know, I think we obviously view the FTC as having the authority under Section 5 of the FTC Act, but you know, the parade of horribles and the sky is falling concerns, similar to what Peter mentioned with respect to the board decision. You know, I think if you look at states where there are no non-competes, excuse me, such as California, I think Oregon and North Dakota, you know, the tsunami of bad things just hasn't happened, and regardless of whether you think there's a correlation between not having non-competes or not, you know, the economy of California, I don't think it's disputed. I think it's one of the 4th largest in the world. I mean, I think it hasn't hurt the California economy. It hasn't hurt California employers. You know, the tech industry there has been able to thrive, notwithstanding the reliance that tech companies have had to place on confidentiality and trade secret laws. So, you know, I think that's a good example of how the concerns that employers have that drive usage of non-competes in terms of confidentiality and trade secrets can be you know, appropriately addressed through those related laws, without harming worker mobility and while still preserving economic interests of employers. And I think, you know, recently the UK has also announced that there may be legislation that's forthcoming limiting use of non-competes. I don't think this is an issue that, and I think it, you know, was proposed by a very pro-business community in the UK. I don't think this is an issue that's unique to the United States, and you know, it's one that presumably employers and businesses will benefit from as well, because they'll be more able to enter the market and more able to compete for workers.
Ladies and gentlemen, I think our time is up now. First, I'd like to thank again the Seyfarth Shaw Law Firm for helping with the CLE, and of course, thank Susan Bond, people at the College of Labor and Employment Lawyers, and thank all of you, and particularly thank Deputy General Counsel Peter Sung-Or. Appreciate you taking the time to spend with us today. Look forward to further conversations on this, and for all those participating, please keep a lookout for other programs sponsored by the College of Labor and Employment Lawyers. With that, I thank all of you, and we're going to close out the session.
Thank you, Evan.
Thank you, Evan.
Bye-bye.
Thanks, everyone.